The entire AI revolution, it runs on one thing: data. To learn, to create, these AI models have to comb through just massive amounts of text and images from all over the internet. But here's the thing, a lot of that data is copyrighted. And that has kicked off this huge legal showdown between tech innovators and creators. The whole thing boils down to one central question: what's fair?
So let's just get right into it. This is the billion-dollar question that courts, tech companies, and creators are all wrestling with right now. When an AI company hoovers up copyrighted books, art, and music to train its model, is that a legitimate fair use, for a new transformative purpose? Or is it really just the biggest act of copyright theft in history?
So how did judges even begin to figure this out? Well, they use this four-factor test. Now, it's not some simple checklist. It's more like a balancing act. They have to look at the purpose of the new use, the nature of the original copyrighted work, how much of it was used, and maybe most importantly, the effect this new use has on the market for the original. Every single case we're about to dive into comes down to how a judge weighs these four things.
Okay, so here's our game plan. We're going to start with the first major court ruling that really drew a line in the sand. Then, we'll get into a dramatic split that happened out in California, try to decode why these judges disagree so fiercely, and finally, take a look at what all this legal chaos really means for the road ahead. First up is the case that drew the initial battle lines. And what's interesting is, this wasn't even about generative AI like ChatGPT, but it was the first major court opinion on AI training. And believe me, it set the stage for everything that was to come.
All right, so the players here are Thomson Reuters, who owns the legal research giant Westlaw, and this little startup called Ross Intelligence. Ross was trying to build its own competing AI search tool. And here's the kicker. To train its AI, it ingested copyrighted legal summaries, these things called head notes, directly from Westlaw. Yeah, its main competitor.
So how did the judge break this down with the four factors? Well, if you look at the scorecard, you can see a couple of factors actually favored fair use, but two of them were absolutely decisive. Factor 1, purpose, went to Gingstros because, well, it was a commercial product that was directly competing with Westlaw. But the real knockout blow? That was Factor 4, market effect. The court decided that Ross not only harmed Westlaw's business directly, but it also harmed the potential market for licensing that data for AI training.
This quote really gets to the heart of the whole decision. The judge basically created a brand new argument. If a market could exist for licensing your data for AI training, then someone just taking that data for free is causing market harm. This was a massive win for copyright holders, and it really put the entire AI industry on notice.
But of course, the story did not end there. Oh no. Just a few months later, things got really, really complicated. Two new cases, this time about generative AI, landed in the very same court district in California. And get this, in the span of just 48 hours, two different judges issued rulings that pretty much completely contradicted each other, creating this deep, confusing split in legal thinking.
So this time, we have groups of authors suing the AI companies Anthropic and Meta. The claim was that their books were used, without permission, to train the large language models Claude and Llama. And here's the crucial part. A lot of this training data allegedly came from shadow libraries, which, let's be real, is just a nice way of saying massive online collections of pirated books. Okay, first up, in the case against Anthropic, the judge's ruling was a win for the AI company, but with a huge catch. You can see on the scorecard that he focused heavily on Factor 1, the purpose. In fact, he called the AI among the most transformative we will see in our lifetimes, basically arguing the tech was so new and different that its purpose had to be fair. But, and this is a huge but, he also ruled that the act of just storing a massive library of pirated books could never, ever be fair use. That's a really important distinction. Then, just 2 days later, a different judge, Judge Chhabria, also ruled in favor of the AI company in the case against Meta. Now, he also agreed the use was transformative, but his reasoning was completely different. He didn't really focus on the whiz-bang technology aspect. Instead, he zeroed in on Factor 4, the market effect. His ruling really came down to a simple point. The authors just didn't bring any real evidence to the table showing that the AI was actually hurting their book sales.
And this is where it all comes to a head. For Judge Chhabria, everything hinged on market harm. He literally said that this fourth factor is, and I quote, undoubtedly the single most important element of fair use. This puts his entire philosophy in direct conflict with the ruling from just 2 days before.
So let's just recap. We have two wins for AI companies, which sounds great for them, right? But they're based on wildly different, even contradictory legal theories.
So let's break down exactly why this disagreement is so important and why it spells so much trouble for the future of AI and copyright.
I mean, this is what makes the whole situation so wild. Just look at how similar these cases were on paper. Same type of generative AI, same type of training data, same court district, and the decisions came just 2 days apart. On the surface, they're practically identical, but the reasoning behind those rulings, worlds apart.
Okay, here's where that split becomes crystal clear. On one side, you've got Judge Alsup, who's all about Factor 1. His logic is, this technology is so revolutionary, so transformative, that's the most important thing. But then you have Judge Chabria, who says, hold on, Factor 4, market harm, is what really matters. They were even split on piracy. For Alsup, using pirated data was an automatic loss. For Chabria, it was bad, but you still had to prove it actually caused financial damage.
And this disagreement, it wasn't subtle or hidden in legal jargon. In his own ruling, Judge Chabria directly took a shot at Judge Alsup's reasoning, accusing him of, and I'm quoting here, blowing off the most important factor in the fair use analysis. Wow, that's not just a legal disagreement. It's a deep, fundamental divide on how we should even approach the defining technology of our time.
So where does this leave everyone? You've got AI developers, authors, artists, musicians, and they're all stuck in this state of profound uncertainty. Let's take a look at what the road ahead might look like in this completely fractured legal landscape.
First, let's just be really clear about the scale of this fight. These are not just a few isolated incidents. Since 2022, over 75 of these AI copyright lawsuits have been filed. The cases we've just discussed, they're really just the opening shots in what's shaping up to be a very, very long war.
And now, a powerful new player has entered the ring, the U.S. Copyright Office itself. In a recent report, the office sided pretty heavily with creators. It expressed a lot of doubt about these broad fair use claims from AI companies, and, very importantly, it endorsed the theory of market dilution. That's the idea that AI harms markets just by flooding them with competing content. This basically hands copyright holders a whole new weapon for their legal arsenal.
So what does this all mean for the people who are actually on the front lines? Well, for AI developers, the message is becoming pretty simple. Your data source is everything. Using pirated works is a massive legal gamble. And for creators and copyright holders, the lesson is to focus on proof. You can't just go to court and claim your market is being harmed. You need to show them the receipts, concrete evidence of financial damage, especially to that potential new market for licensing your work.
Which, of course, leaves us with the ultimate question. Our current copyright law was written decades before anyone was even thinking about generative AI, and it is being stretched to its absolute breaking point. So will the courts eventually figure out a consistent way to apply these old rules to this brand new world, or is this chaos going to force Congress to finally step in and write a whole new playbook for copyright in the age of artificial intelligence? The answer, whatever it is going to define the future of both technology and creativity as we know it.